Good afternoon. I'm going to go ahead and get started. I am Elaine Alston. I'm one of the attorneys at Copenbarger and Copenbarger, and I'll be presenting today's webinar, Trustees' Rights and Remedies for Rental Properties. First, a little bit about me. I've been practicing for about 37 years. Some 32 years ago, I started actively advising landlords and some tenants regarding their respective rights. I've tried numerous unlawful detainer trials and litigated numerous civil actions involving rental property and the rights of landlords and tenants. I have helped many a landlord navigate through rent control issues. The information today is being provided for educational purposes. It is not intended as specific legal advice. It is geared to a general audience. Every matter is unique, and thus using the information provided herein before doing it, please consult with your personal attorney to make sure that it's correct for your specific situation. Copenbarger and Copenbarger have a number of attorneys prepared to help our clients with their various needs. We have an extremely strong estate planning department led by Lloyd Copenbarger, who is the founder of Copenbarger and Copenbarger back in 1979. Working with Lloyd in the estate planning division is his son Larry, one of our newest partners, Victoria Raymond, and Mark Krause. Our estate administration team consists of James Kosaroff as the team leader with attorneys Mark O'Brien and Megan Wilson. I work closely with the administration team, working on litigation matters that arise during the administration of trusts, as well as handling independent trust litigation. We have a very strong business and tax division led by Sunny Bornan and Catherine Grout. Their help is indispensable for those starting and or operating businesses, including rental properties. We could not do the work without our staff of paralegals and legal assistants. Here is a recent group photo taken outside of our Santa Ana office. We have 8 offices in California to serve our clients. Santa Ana, which is known as our South Coast Metro, is our main office. We have an office in San Jose, Temecula, Santa Cruz, Pasadena, San Diego, Sacramento, Laguna Hills. I work out of both the Santa Ana office and the Laguna Hills office primarily. We also actively use Zoom and Microsoft Teams to meet virtually with our clients, and also for some court appearances. I have broken today's webinar into 3 parts. Foundation. The second part is trustee communications, and finally, conflicts and remedies. Foundations of trustee authority and duties. There are 3 key roles in handling trust properties. First, you have the trustee, and the trustee manages the property. Then there's the beneficiary, who does not manage the property, but is entitled to benefits under the trust. And the third role is held by the tenant, who has legal occupancy rights that must be respected. When a trust consists of real property assets, generally, the trustee is required to make sure that the property is fully insured, pay the mortgage and property taxes, and make sure it's maintained in good condition and repair. Many of the trusts require that property be income producing, i.e., rented at their full market value. Trust law governs the trustee's management of the properties. As a first step, the trustees should look to their specific trust documents. The trust may provide specific instructions with respect to one or more of the real properties. For instance, a vacation home, the trust may indicate and state that the trust property is to be held as a vacation home for the use and enjoyment of my children and grandchildren, which would mean that the trust does not intend for the property to be leased out for a tenant. Some trusts contain provisions that a certain beneficiary may occupy real property, and there may be a specific set of instructions with respect to that occupancy, such as the occupant may be required to pay rent, may be required to cover the cost of repairs, may have the responsibility of paying the property taxes. So each trustee should look specifically at their trust documents when dealing with property to determine whether or not they can rent out the property. Where the trust is silent, then the duties of the trusts are governed by California trust law, which means basically that a trustee must make the properties income producing. Trustees have a fiduciary duty to manage the properties within the bounds of California law. They have the duty of loyalty. They have the duty to act in good faith. They must make careful and well-informed decisions benefiting the trust and the beneficiaries. Acting in the beneficiary's best interest, and again, it's in the beneficiary's best interest, not the best interest of the trustee. There is a risk of personal liability to a trustee if the trustee mismanages or violates their fiduciary duties. The trustee can be held liable for losses and damages, and in some cases may even be surcharged punitive damages. What should a trustee do to make sure that the trustee is not breaching the fiduciary duties so as to avoid personal liability? Well, they should seek legal and or financial advice and document every decision, including the facts and reasons a specific decision was made. Keeping records is extremely important. And you will hear me say it over and over again throughout the webinar. Keep detailed financial records, keep detailed communications between the trustee and the tenant, the trustee and the beneficiaries, and the trustee and advisors such as legal, accounting, and real estate advisors. I like to advise trustees when they become a trustee that they should take the following steps. Make sure that the real property is entitled in their name as trustees. Look at the trust to see if there are special instructions relating to the property. Review documents relating to the property, such as mortgages, loans. Take a look at the property tax records to make sure all of those are in good order, that the property taxes have been paid and the mortgage is up to date. Make sure the property is insured, and that means not only that it has insurance, but that the insurance is full coverage insurance and will cover the trust and the property for fire, flood, for injury that may occur on the property. Review any lease and rental agreements in existence for the property. The trustee should go to the property itself and physically examine the property. However, if it's rented and there's a current tenant, then notice must be given to the tenant that there intends to be an inspection of the property. During the physical inspections, take photographs. Document the condition of the property, the good, the bad, and the ugly. Determine if the people in the real property have valid rental agreements. Determine if there are any habitability issues if the property is a residential dwelling. Determine whether the property is in a rent control area. Determine if the trust is currently receiving fair market rent for the premises. Determine when the last rent increase was given. Determine what the lease and the rental agreement states regarding the rental rate and rental increases. If the trustee is unfamiliar with California tenant law, the trustee should consult with an attorney regarding the rights and obligations as a landlord. Again, as I said earlier, the key for a trustee to avoid personal liability is to keep detailed records. A record should be made as to each of the steps above, date, the conclusions, what the determination was based upon. And for example, if the trustee determines that the home is not being rented for market rent, the detailed record should show that the trustee talked to a real estate person who's familiar with the area, that the realtor saw pictures of the inside and outside of the home, that the realtor compared this home, the particular home, with other homes in the area of the same size, and showed that the realtor's comparisons for the home, why the rent is lower or higher than the market rent by X dollars. In keeping records, keep clear records as to what rent is received. Recently, I had a trustee who came in who had multiple pieces of property that he rented out. He gathered all the rent checks and made one deposit into the bank, but didn't keep records. So it was very difficult to tell what each unit was bringing in and whether each unit was current, since there was only one sum going into the bank. So again, the record should be kept so that for each unit or for each house, what rent came in, when it was paid, what month, and the amount. And if there were any deductions made by the tenant for perhaps a repair, that needs to be tracked as well, so that there should be detailed records. Now we're going to move to the second section, which is trustee communication. New trustees must notify all tenants of the change in ownership. This is required by law. Name, telephone number, and address. Now, you don't have to share your personal cell phone number, but you do have to share a number that they can reach. You don't have to share your home address, provided you can provide them with a business address. If you've hired a property management company, then that property management company's address and telephone number can be the contact for the landlord. Make sure the tenants are provided in writing where they are to send or deliver their rent monies, and if they can pay in person, what hours they can pay in person. You may want to provide a method for auto pay, such as Zelle. Make sure the tenants know whom to contact when repairs are needed, who to contact in the case of an emergency. Make sure as a trustee you understand the laws with respect to entering a tenant's property. Imminent danger, there's a fire, there's a flood, there's a gas leak. You can go right into the home, whether the tenant's there or not. It's an immediate emergency, but it must be an imminent danger. The fact that the dishwasher is broken is not an imminent danger. You have to give 24 hours notice if you wish to enter the premises, and you need to tell them what the purposes of the entry, i.e. an inspection, or perhaps to repair the dishwasher, or to repair and do some decoration of the premises. This notice can be given to them in writing by handing it to them. You can also post it on the premises. If you decide that you want to mail notice to them, the law requires that they have an extra 5 days, so that you would have 6 days notice if you're mailing it to them. Don't count the day that you put the envelope into the mail, but you do count the last day, the 6th day. Trustees are considered landlords and are required to abide by all the laws regarding landlord relationships. Ignorance is no excuse. If you don't know the law, talk to an attorney. As a guide, you can go to California Civil Code, section 1940, which is a section called hiring of real property, and you can read the law there. But again, there's a lot of nuances and there's a lot of cases that have interpreted those statutes. So that's a good place to start. But again, I urge you to talk to your attorneys. You all, trustees, need to educate themselves on what the law requires for residential dwellings to be considered habitable. There can't be any broken windows. There must be locks on the door. They have to have heat, but not air conditioning. They have to have hot water. So again, you need to be familiar with what is regarded as a habitable premises, because if a property is uninhabitable, then you will have difficulty in evicting, you will have difficulty with respect to collecting rent. Trustees must be careful not to discriminate in letting of real property. We have to comply with the Americans with Disabilities Act, the California Unruh Acts. Trustees will have to abide by California law, even if the trust documents direct the trustee to violate the law. For example, I've seen trusts where the settler did not want a particular ethnic group to reside in the home, or didn't want people with children to reside in the home. Those particular provisions of the trust will be regarded as illegal, and the trustee must follow California law. Our firm has done several webinars regarding landlord and tenant issues. You are welcome to view those, and they may answer some of your questions regarding basic tenant landlord law. Understand that unless it's a dire emergency, that 24 hours notice must be given before a rental property can be entered. The entry must be between 8 and 5 p.m. A trust is required to make the trust property income producing and thus try to obtain the best rental rate possible. However, state law governs how much of a rent increase can be given. In 2019, the California passed a bill which is known as AB 1482, which was essentially a statewide rent control bill. AB 1482 went into effect on January 1st and expires on January 1st, 2030, unless the legislature extends that or modifies that. And it does two main things. One, it limits annual rent increases to no more than 5% plus local CPI, or 10%, whichever is lower. And the CPI is the Consumer Price Index, and that will determine the inflation rate for your area. It's an annual rent increase. So that is why I tell my trustees to go and determine when they first take over as to when the last rent increase was given. Because if the rent increase was given a couple of months before, they won't be able to raise rent for at least 10 months. Also, as far as rent increases, you must look to the lease and rental agreements, because the lease and rental agreement may have specific provisions relating to rent increases. Again, state law will preempt the lease. If the lease says they get a 25% increase, the lease will be deemed to have to, or the trustee will have to provide with the state law concerning rent control. A tenant cannot waive their rights to the protections under 1482. Any attempt to do so is unenforceable. The other thing that AB 1482 did was required that a landlord have just cause in order to terminate a tenancy. which means under the just cause, it's either the at fault where the tenant has failed to pay rent or has not complied with some of the terms of the rental agreement, etc., or where the landlord wishes to move a family member into the property or wishes to take the property off the market so that major renovation can be done. Copenbarger has presented a webinar discussing the termination for fault and for non-fault situations. So you're welcome to look for those and they may answer your questions. I have a question here that says, is this webinar applicable to a revocable living trust? Yes, it is. Under most circumstances, that's exactly the type of trust that a trustee is taking over where there are real property assets. The question is also, if there is no change in address, name, or phone number, is formal notice required upon the death of the trustor? Yes, because there still would be a change in the name of the trustor. Because if a trustor dies, well, if the trustor dies and the trustor was not the trustee and the same trustee, then there has not been a change. So that is sufficient. But if the trustee changes or the trust itself changes, then yes, notice is required. The trustee must not violate rent control ordinances. If a rent control ordinance is more stringent than AB 1482, then the rent control statute prevails. For instance, if the rent control statute says that the rent can only be raised 5% or can only be raised to CPI, then you will not be able to add 5% for the CPI. So again, you need to know as a trustee whether or not your property is in a rent control area and what that rent control ordinance provides. And again, I advise you to talk to an attorney on that matter. Holding and using trust income. All rental income must be deposited into a trust account and used for trust-related expenses or held for future distributions. There is no need, unless you have separate LLCs for each property, for the property monies to be deposited into separate accounts for each property. If it's being managed by a trust and there is not a separate LLC or other company that owns a particular piece, all of the money can go into one account. Now, from that account, the trustee will pay the expenses such as the mortgages, the property tax, any repairs, the insurance, the costs of legal advice, the like. That will come out of the trust funds. Then the excess, if you will be distributed income to the beneficiaries. And that has to be distributed in accordance with the trust. Unauthorized distributions can result in liability. And I want to remind trustees that they have to treat beneficiaries equally. So if the trust provides that the beneficiaries shall receive, each of them shall receive distributions, then the trustee cannot just give one beneficiary a distribution and not the others. So again, you have to treat the beneficiaries who are equal under the trust equally in the same manner. The trustee in managing the property will have to handle tenant-caused damages. If there's damage, then the repairs can be deducted from security deposits. The trustee must be very careful to document all damages and follow all state guidelines with respect to the damages. Again, Copenbarger has a webinar on on landlord and tenant law, which will answer some of the specific questions in this area. The trustee will also have to return deposits. Security deposits under the law must be returned within 25 days of the date the tenant moves out. It is crucial that the landlord document any damage and provide the tenant with an itemized list of the deductions. Again, it's the documenting of everything that counts. Photographs, provide an itemized statement listing repairs and what the cost for cleaning. Again, keep receipts. And quite frankly, where possible, hire licensed professionals, because you can then, the bill is right there, you have that amount going through. If you're using an employee, you have to count down and state what the hourly rate for that person is and how many hours they took to do the repair. Again, we have a webinar that addresses this in more detail. Now we go to the third part of this webinar, and this is conflicts and remedies. Trustees have to, if they want to remove a tenant, use the state law provisions. And if a tenant refuses to get out after proper notice is given, then the trustee can use the eviction processes. But again, all the provisions and all the requirements for an eviction must be performed. It doesn't matter that the person living in the home is a beneficiary or the person living there is a relative. All of the processes have to be used, which means that the tenant must be given a notice telling them that they are either in fault, i.e. that they haven't paid the rent, or that the property is being taken off the market, or if it's a lease term where the lease was for a year and you want to terminate it at the end of the year, they have to be given notice that it's being terminated. They have to get the notice that they're to leave, and if they don't leave, that's when an unlawful detainer complaint is filed and served, and ultimately, if required, goes to trial. Another question that comes up a lot with respect to rental properties held in trust, sometimes the rental property needs to be sold. And there are options for selling while a tenant is occupying the property. It makes it more difficult because, again, notice has to be given to the tenants that the property is going to be shown. It often, with a tenant in the property is not in the best showable condition. As most of us know, that houses are often staged for sale, and you can't do that when you have a tenant that's occupying. So often having a tenant in the home will reduce the market value of the actual home itself. But again, that's a specific area that you need to look at the specific circumstances. For instance, if this is a beneficiary who has the right to occupy the property until it's sold, then you're not going to be able to do eviction. You're going to have to work around the issue of the beneficiary living in the home until it's sold. And trustees often have issues where they are going through the process of terminating the tenancy of a family member, of somebody who's part of the trust. It can result in a lot of emotional and legal challenges. And I, again, urge you to talk to an attorney about it. And as with everything, document, document, document. Explain what the decisions are, explain why you're doing something, and the various options and why you chose the particular options. Beneficiaries may sue trustees for mismanagement, lack of transparency, breaches of duty that will result in a financial loss. For instance, if a trustee doesn't make the mortgage payments and the home goes into foreclosure, then the beneficiaries are going to look to the trustee to take care of all the costs and the damages related to going into foreclosure. If there's an issue with the amount of money that's available in the trust, then that is something that needs to be talked with the beneficiaries and a solution found before a home goes into foreclosure or gets sold at a foreclosure sale. Beneficiaries have a right to know what's going on. So when a trustee makes a determination with regard to the leases or who to lease to, the like, there's a requirement that the trustee explain their actions to the beneficiaries. And breaches of duty that result in a financial loss. If a trustee doesn't pay attention to the fact that the people in the property are not the people that are on the rental agreement, or if the property is allowed to fall into a condition that would be regarded as uninhabitable, and the landlord trustee has not repaired the property, that again would expose the trust to financial losses and thus would be a personal liability risk for the trustee. There are some mistakes that a trustee makes, and some of it is the failing to notify tenants, the failure to give the tenants the right notice to be able to enter the property, failure to communicate with the tenants to where they're to pay the rent, failure to give the proper notices when it comes to evicting. Another area that the trustee fails on is misusing trust funds. Again, trust funds are not for the benefit of the trustee, and distributions are important, but the mortgages, property taxes, repairs to the homes need to be made. So again, the trustee will be personally liable if they make mistakes in the area of what the use of the trust funds. And some trustees tend to regard the property as their own personal property, and they can make all the decisions and they don't have to be rational decisions. That is untrue. The property needs to be treated as trust property, and that prudent decisions need to be made. In other words, if there are 3 people who want to rent the property, the trustee can't favor one who wants to pay a lower amount just because he likes those people. Again, it's prudent decisions that have to be made. The question is, how can a trustee reduce the risk? Well, quite frankly, communication with the beneficiary constantly, openly resolves a lot of issues. Because beneficiaries want to know what the trustees are doing and want to have it explained to them. Again, it doesn't mean that you have to talk to them every day. It doesn't mean that if the dishwasher breaks that you have to call all the beneficiaries and tell them the dishwasher broke. But in a monthly or perhaps every 3 months, a report telling them that you had to make certain repairs to the home. The hot water heater broke, the dishwasher broke in one house, that you had to change the locks on another, so they know what's happening. Again, consulting counsel on a regular basis really make sure that you're in compliance with the laws. The worst thing that can happen is you find that you've violated, for instance, the UNRU Act or the Americans with Disability Act, and that the prospective tenant or the previous tenant suffered substantial damages from your actions. The beneficiaries are going to be looking to the trustee to make those whole. So again, consult with counsel. And as I said earlier, document every action taken regarding the property. That way, if somebody says, well, why did you do? You say, at the time, I was told this was the amount of fair market rent, that I pulled the CPI, this was the CPI, I added 3% to the CPI to come to the level of 10%. We issued that rent increase notice. At least they know what it's based upon and why. So again, it's document everything. Photographs are a great way to document the condition of a property, both before repair and after repair. The remedies. Well, again, we have eviction and court petitions. A trustee can petition the court for directions, i.e., if there's the trust is confusing, or if the beneficiaries are arguing about a particular provision that seems to be ambiguous, the trustee can go into court and say, I need direction with respect. I'd like to do the following acts. I want permission to do it. And the courts will review those and give direction. The trustee can initiate eviction proceedings and proceed with those to get tenants out of the property where there has been a fault on the part of the trustee, on the part of the tenant, or where there is a reason for the trust to take the property off the market, perhaps to repair a number of damages or to sell the property. A trustee is also responsible for looking to see if there has been malfeasance on behalf of an earlier trustee. And if so, to then discuss and seek recovery from the previous trustee. For instance, if a piece of property is valued at $5,000 rental value, but the trustee right before you rented it out to their best friend at $1,000 a month and gave them a 10-year lease for $1,000 a month, you won't be able as a trustee to bring that rent up to $5,000 a month, because there is a written rental agreement saying that it was $1,000 a month. And as we discussed, 10% would be the maximum increase that you could do to bring it up. So it would be brought up very, very slowly. However, if you can document and prove that the fair market value was $5,000 a month, then the previous trustee theoretically should be responsible for that payment. So demand should be made, and perhaps discussion of whether or not to bring legal suit against the trustee for such flagrant abuse. Current trustee may seek damages of restitution through legal action for harm caused by the prior trustee. When to seek legal support? When disputes arise, legal boundaries are unclear, and risks of liability increase. So again, I urge you to seek legal advice. Question: how can we help? We can help you provide a plan before it is needed. We can update the terms of leases and rental agreements to make sure they're appropriate and follow the law. We can also change rules and regulations so that tenants are abiding by a new set of rules and regulations. We can give advice to landlords regarding the correct notices, and we can help with prosecuting and defending evictions. Why our law firm? We've been working with qualified professionals since 1979. We have 12 attorneys and 3 CPAs on board, over 350 years of combined attorney experience. We have several attorneys with advanced tax degrees. We have certified specialists in probate, estate, litigation, and trust law. We've got over 45 highly qualified staff. We have a diverse staff with multiple skills. And we have 8 offices to help you, as well as virtual abilities to communicate with clients all over the state. Please feel free to call us. You can visit our website. You can email us. You can do a digital evaluation. So I would ask that you do that. So please check in the link and ask that you do that. I have one final question here. It says, if a trust property is held by an LLC, will the step-up tax basis exclusion be unavailable to the beneficiary? Well, I'm going to tell you right now, I'm not a tax expert, and I will refer that question to our tax department, and either Sunny Borna or Catherine Grout will get back to you with an answer to that question. Thank all of you for your patience, and I look forward to hopefully meeting with some of you personally.